Hey guys, and welcome to Module 1, and this will be my short module lecture. And this week I'm just going to be discussing briefly the American federal court system, so you have an understanding as to the structure of the federal court system here in the United States, the roles of each specific court that we will describe, the types of cases that each level might hear, and then the process. In other words, I'm just going to explain briefly how a case might reach the U.S. Supreme Court. Now, all of these are part of the critical elements for your short paper this week. So that's why I want to discuss each of these so that you'll have a good understanding as to how they function. So first, let's look at the tiers of the American federal court system. First, we have the district courts. Now, these are the lowest level in the federal court system. There are 94 judicial districts in the 50 states and territories. They have no appellate jurisdiction, and they are original jurisdiction over most cases. In other words, the district courts in the federal court system are the trial courts. They are the primary trial courts, except for those few cases in which the United States Supreme Court has original jurisdiction. All right? So they have 94 judicial districts. So what exactly does that mean? Well, typically, states are going to be broken down into districts, judicial districts, and often it's going to be based on population. For example, in California, there are 4 federal judicial districts. So when I was a police officer, a police detective working in Southern California, we were part of the Central District of California. So the specific title for the district that I worked in was the United States District Court for the Central District of California. So in California, again, we had 4 districts. Whereas if you take a state like Oregon, Oregon only has 1 district, and that is titled United States District Court for the District of Oregon. So a lot of times it's going to be based on the size of the state, the population of the state, and so forth. Okay, but 94 judicial districts in 50 states. So this is good information. So as you're looking at your the assignment guidelines and the grading rubric, in order to get an exemplary rating, for example, on tiers, this is the type of information you might want to supply, and then cite a source telling you how many judicial districts there are in the United States. All right. So again, district courts are the primary trial courts within the federal judicial system. Next, we have the Court of Appeals. Now, these are the intermediate level courts within the federal system. And intermediate means between the trial courts, district courts, and the Supreme Court. So this is the first level of appeal that often takes place. Now, as you will learn in the video, there are 12 regional circuit courts, including the DC Circuit. All right, so what does that mean? Well, based on the map that was shown in the previous video that I posted in the announcement, you should be able to see how states are located in specific circuits. All right, so much of the western portion of the United States, California, Washington, Oregon, Nevada, those type of states are part of the Ninth Circuit Courts of Appeals. All right. And then on the East Coast, if you look at the short video I offered you, you'll see how some of the eastern coast states, eastern states and central states are structured. All right. So if, for example, when I was in the Central District of California, if an appeal was made from the Central District of California to the Circuit Courts of Appeal, it would go to the Ninth Circuit because the Ninth Circuit includes California. Okay. Now remember, they have no original jurisdiction, strictly appellate. In other words, they have no original jurisdiction. In other words, no case begins here. All they hear are appeals from the district courts within their circuit. And that's their primary responsibility. And I'll go into a bit more detail about that here in just a second. But they are strictly an appellate court. So there is no trial, there is no testimony. A lot of it is based strictly on court pleadings and filings, And oftentimes, attorneys are allowed to argue much like they are in the Supreme Court, and the justices can ask questions, seek clarification, and so forth. And finally, the highest court, obviously, in the United States is the Supreme Court. It's the highest court in the federal system. And obviously, it's the supreme law of the land. We have 9 justices that meet in Washington, D.C. Appeals jurisdiction through certiorari process, limited original jurisdiction over some cases. So in other words, unlike the courts of appeals, the Supreme Court decides which cases it wants to hear. And shortly, I'll describe how they go about deciding those cases. Now, the role of each, again, the United States District Court is the primary trial courts of the federal court system. They have original jurisdiction over most civil and criminal cases. The United States Circuit Courts of Appeals, their role a lot of the time is to decide whether or not lower trial courts applied the law correctly. They also have an important policy-making role, and a good example is outlined on page 37 of our textbook in the case of Hopwood v. Texas. That's just an example. Since most of the cases do not go beyond the circuit courts of appeals, they do have a significant policy-making role. So if they were to, if the Ninth Circuit, for example, were to make a ruling, that ruling would apply to only those states within the Ninth Circuit. But if someone appealed to the Supreme Court and the Supreme Court elected not to hear that appeal, then the case that was decided by the Ninth Circuit, for example, would be binding on those states. In other words, that's the law of the land. So they do have a significant policy-making role, right? And they also have an error correction role. They make sure that the lower courts apply the law correctly, and that's oftentimes the basis for the appeals. The Supreme Court, again, decides whether lower courts apply the law correctly, and then, of course, the Supreme Court is a significant policymaker. An excellent example may be found in the area of racial equality, Plessy v. Ferguson, Brown v. Board of Education. Our textbook on pages 30 through 32 has a lot of good examples on the type of policy-making decisions that this court's made. So if we look at law enforcement, for example, issues regarding search and seizure the Supreme Court has made, and those are policy-making. In other words, police have had to change their policies. Miranda, in terms of advising somebody of their constitutional rights prior to any questioning once they're in custody. Again, it's a policy-making decision, policymaker. So the Supreme Court has a significant influence on all of us. Remember, it is the law of the land, and once the Supreme Court rules on a particular case, that is the law of the land, and all courts in all states have to apply those rulings. So regardless of where you're at in terms of criminal justice, for example, that's going to be the law of the land. Types of cases, again, the district court is the entry point for most cases in the federal judicial system, and that could be criminal, such as bank robbery, and civil, such as same-sex marriage. Circuit courts, as I mentioned earlier, unlike the Supreme Court, must hear all appeals. Those cases might run from the frivolous. Let's say an inmate is suing a prison because he doesn't like their food. All right, the district court rules against him, and since he has nothing but times on his hands, he files an appeal with the circuit courts within the district in which that prison is located. To those type of cases that raise serious constitutional questions, such as same-sex marriage. All right, so again, circuit courts are pretty backlogged because of the number of appeals that are filed. And again, unlike the Supreme Court, they have to hear or at least review each of those appeals. So those are the types of cases. Now, Supreme Court, in terms of the type of cases that they might elect to hear, are cases of national importance, segregation, abortion, same-sex marriage, cases in which a lower court invalidates federal law, and Gonzalez versus Rake is one of those that has to do with medical marijuana, in which the Ninth Circuit Court of Appeals ruled that federal drug enforcement officers do not have the authority to seize marijuana plants that somebody was growing because the state that they lived in, which was California, allowed for medical marijuana use. And basically what happened is the Ninth Circuit invalidated federal law because at that time, and at the time of this lecture, federal law was that marijuana was illegal. So whenever a lower court invalidates federal law, the Supreme Court is likely to hear that case to clarify the status of federal law. And oftentimes they're resolved with split decisions within a circuit. For example, same-sex marriage. So there was a dispute between the Sixth Circuit and the Ninth Circuit at about the time same-sex marriage became a political hot button, so to speak. And so the Supreme Court elected to hear that case because they were split. In other words, Sixth Circuit decided that states did have the right to define marriage, and the Ninth Circuit said states, such as California, for example, could dictate the constitutionality of same-sex marriage. Process, it's all about certiorari. In other words, 4 of the 9 justices vote to grant a writ of certiorari or writ of cert. Those cases justices consider important, such as religion in public schools, police searches of cell phones, and things like that. So again, you have to have 4 justices elect to hear the case. That's what's important here. Okay. Appeals from courts of appeals, split decisions from circuit courts, as I talked about, same-sex marriage, cases in which federal law has been invalidated at the trial court level. These are the types of things in the process that the federal courts, especially the Supreme Court, takes note of. Original jurisdiction. Now, the Supreme Court does have original jurisdiction on just a handful of cases, right? In other words, these are cases that are heard directly by the Supreme Court without going through the appeals court process. Oftentimes, there aren't really a whole lot of these cases that come forward like this, but for example, if 2 states had a legal dispute, let's say California and Arizona had a legal dispute over the Colorado River and water rights, that case between the 2 states would be heard by the Supreme Court automatically. They would have original jurisdiction on those types of cases because the other side of the coin would be, where should such a case be heard, in California or Arizona? So as you can see, when states have 2 competing interests on something, or they make a legal challenge against each other, then those cases are going to be heard by the United States Supreme Court. Those are the type of cases in which they have original jurisdiction. Original jurisdiction cases are very rare. Typically, no more than 2 cases per year fall under this category. So a very small amount of cases does the Supreme Court have original jurisdiction to the point that it is heard by the court. So finally, looking at a case example of how a case might reach the Supreme Court, I've just highlighted here briefly the case of Hollingsworth versus Perry, that deals with California's Proposition 8 back in 2008. Proposition 8 was a proposition passed by the California voters that defined marriage as a union between a man and a woman. The state courts upheld the proposition, and opponents sought relief in federal court, violation of the United States Constitution, specifically the 14th Amendment. So in 2010, a federal judge in the Northern District of California, which is up near Sacramento where the capital is, ruled that Proposition 8 violated the 14th Amendment, the Due Process Clause and Equal Protection Clause. All right? So he basically invalidated Proposition 8. Now, proponents of Proposition 8 appealed to the Ninth Circuit Court of Appeals, which is the circuit in which California is located. And in 2012, they reached the same decision as the trial court, which basically said Proposition 8 was unconstitutional and violated the 14th Amendment. Proposition 8 advocates then appealed to the U.S. Supreme Court, which granted writ of certiorari. And on June 26, 2013, the Supreme Court ruled on the case Hollingsworth v. Perry. It was a complicated ruling, but the decision of the district court was upheld, which meant that became the law in California. But then, of course, when the Supreme Court ruled that the district court made the right decision, it basically nullified Proposition 8, and that's about the time the Supreme Court decided that same-sex marriage was constitutional and that states could not prevent those marriages because it violated the 14th Amendment. Okay, so that's an example, for example, how a case might reach the Supreme Court. So as you're thinking about examples, think about something like that, okay? Remember, you're trying to identify the courts that are involved along the way. So again, things start out at the district court level, if we're talking about federal court structure, then they're appealed to the circuit courts of appeals, and then ultimately to the Supreme Court. If the legal issue is a significant legal issue, or fits one of the other criteria that I mentioned earlier. Okay, I hope this helps. Have a good week.